Good afternoon, everybody. Again, apologies for the late start, but I would like to welcome you all very much to this third and final plenary session on the role of international courts in the 21st century, which I have the enormous privilege of moderating. My name is Phoebe Okowa, and I'm Professor of Public International Law at Queen Mary University of London, and I'm also a member of the ICON's Executive Committee. So it just falls on me to introduce our three eminent panelists. We are very fortunate indeed to have three eminent jurists by any definition, and I'm just going to introduce them in alphabetical order. I will start by introducing Shahid Fatima, who is one of the leading public law barristers in the United Kingdom. A Queen's Counsel, she has extensive practice and has appeared before the European Court of Human Rights, the European Court of Justice, and before the Supreme Court of the United Kingdom, as well as before various United Nations bodies. She was, in January 2017, I believe, named as one of the 100 hot lawyers by The Lawyer magazine. She is also the author of an influential textbook on international law and foreign affairs in English courts. And her talk today is going to be on the Strasbourg Court and the United Kingdom. Our second panelist, and as I said, I was only introducing them. This is not in order of either seniority or eminence, is, of course, Judge Silvia Fernandez de Gumendi, who is a president of the International Criminal Court since 2015. She was first elected to the court in 2010 and has therefore been a key part of the tumultuous years when the court has been struggling to live up to the ideals in its founding instrument to guarantee lasting respect and the enforcement of international justice. Before moving to the International Court, she was an Argentinian lawyer and diplomat whose appointments included serving as Director General of Human Rights in the Foreign Ministry. She also appeared in a number of significant cases before the Inter-American Commission and the Inter-American Court. And our third and final panelist, I think, probably needs no introduction, but I will introduce him nonetheless. He is our host, Professor Mikael Rusk-Madsen. The rest, I think, he is the founder and director of ICOTS, the Danish National Research Foundation Center for Excellence on International Courts, and a professor of European law here at the University of Copenhagen. A lawyer and a sociologist, or at least by training, he is currently directing a project on the systematic exploration of the causes and consequences of the proliferation of international courts. He will talk today on authority in question, international courts in the changing world order. And I think I will call on Judge Fernandez to deliver her talk. Thank you very much.
Good morning to everybody. I am extremely pleased to be here today, and I would really want to thank the organizers for inviting me to participate in this event, in this huge event. I understand that you have had already 3 days of great discussions, and I hope that we will have a very good last panel today. I am particularly happy to be invited to participate in what I consider to be an extremely timely discussion on international courts in the 21st century. And I will not be a surprise to you that I will focus on one of these courts in the 21st century, which is, of course, the International Criminal Court. And already there was a biased introduction about tumultuous years, I understand, but we will speak about these years and the challenges ahead. Now, we don't have much time. I will try to really be as brief as possible so we have the time for a dialogue. So let me very, very briefly encapsulate what has led us to the situation today, because the International Criminal Court today is indeed part of a huge surge of international criminal courts and tribunals in the last 25 years. We know that during the 50 years of the Cold War, we have witnessed a huge normative development in the area of international law of human rights and international humanitarian law. Huge surge, a huge development of norms, including also the establishment of courts to monitor these norms and ensure international responsibility of states. And this also will be addressed by the panel today. But at the end of the Cold War, we see something more. We see also efforts to ensure compliance with these norms through enforcement of individual criminal responsibility of the violators, of the perpetrators of the most serious crimes. And this, we know the beginning of this process is the beginnings of the 90s, with the establishment of 2 ad hoc tribunals by the Security Council of the United Nations, the International Criminal Tribunal for former Yugoslavia, the International Criminal Tribunal for Rwanda. Now, at the same time, during these 90s also, this is also in parallel the process of negotiation and adoption of the Rome Statute, the founding treaty of the first a criminal court of a permanent and general nature, the ICC. After the adoption of the Rome Statute, the establishment of more ad hoc tribunals also occurred, and we witnessed the establishment of a number of hybrid mechanisms, and we have Timor-Leste, Kosovo, Sierra Leone, Bosnia and Herzegovina, Cambodia, Lebanon, and most recently, the establishment of the African Extraordinary Chambers in Senegal that have conducted the proceedings against Hissène-Habré, and the Special Criminal Court for Central African Republic, which was also is now in the process of being established. So all these mechanisms are hybrid systems where they try to integrate national and international components. I will speak a little bit further on what is the ICC model compared to these hybrid mechanisms. So all these mechanisms together, they manage to establish or to put international criminal justice, put it firmly on the global agenda. Now, the concept of international criminal justice became an integral element of conflict management and post-conflict resolution. And the ICC, as the only international court with a permanent and general character, is a central piece of this global system of justice, also because the model that was followed is a little bit of a backup system for everything else. And all these mechanisms together have really managed to establish the concept of punishment for certain crimes at the international level. Now we see that impunity is not an option anymore. That doesn't mean that everybody is sanctioned, far from that, but the concept is there. The option of impunity is not there any longer. When we see, for instance, the problem of Syria and with the difficulties to agree on an accountability mechanism for Syria, there is indeed the inability to agree, but because impunity is not accepted as an option anymore, we see in the last months how the General Assembly of the United Nations established a mechanism to preserve evidence for the time when accountability will be made possible through an agreement. So that shows that even when there is no possibility to agree, everybody understands that there needs to be, at some point, accountability for perpetrators of certain type of crimes. Now, what is the ICC model? I talked about these hybrid mechanisms that integrate national and international components. Basically, they have international and national judges trying to work together. The ICC follows a different model. It's fully international, so all judges, all staff of the International Criminal Court, they are international, and they are supposed to be independent of their own national countries, their own national systems. The ICC is complementary to national systems, so the ICC has been established on the assumption, on the premise that it is for states to investigate and prosecute first, and that the court is only going to intervene when national investigations or prosecutions are not possible for whatever reasons. Now, as I said, the ICC is not hybrid, it's fully international, but at the same time, it was the understanding of the drafters of the Rome Statute that the global court could not be associated with one particular system, that it had to reflect the diversity of legal systems and traditions, and the procedural system that is followed by the court is a hybrid system that combines elements of civil law and common law systems in particular. Now, of course, also it's the understanding that the membership, even if they are all international, they also need to reflect the diversity of regions, the diversity of legal traditions, and the diversity and gender. And so that is also a deliberate effort that is reflected in the treaty itself. It's a requirement to have a gender balance and balance of systems in the composition of the bench, of the judges, but also of the staff. Also, an element of the ICC is that it incorporates elements of restorative justice. So the ICC, the International Criminal Court, is not just about investigating and prosecuting crimes and sanctioning individuals. It's not only about retributive justice, but it also, for the first time ever, it allows victims to participate in the proceedings, not participate as witnesses, we've always had that, but participate in their own right to express their views and concerns and to seek reparations. No, that's the model in a nutshell. What has happened in 15 years? We are celebrating the 15th anniversary of the entry into force of the treaty this year. And because we go so fast, next year we celebrate the 20th anniversary, but of the adoption of the Rome Treaty. So the court has already 15 years of operations, 50 years of experience, and a lot has happened. Of course, at the beginning, the court had to go slow. It was building the structure. It was building the institution. Now it is a full-fledged judicial institution with 1,000 staff members, with several field offices. So the headquarters are in The Hague, but we have field offices in several countries where the court is investigating. The first suspect was transferred to the court in 2006. That was the first trial. Now we have 9 individuals that have been convicted, several trials that have been finished, 3 trials that are ongoing at this point in time, and already proceedings for reparations are being conducted in order to, now that there are convictions, the reparations can start. Have to say that among the persons that have been tried and convicted, the majority are non-state actors, and some of them affiliated with terrorist organizations. I say this because several times, in several occasions, they ask me if the court is hindered by the fact that we don't have terrorism as one of the crimes within the jurisdiction of the court. You know, the court has jurisdiction over crimes against humanity, genocide, war crimes, and maybe one day also on aggression. But the way that these definitions have been developed has allowed the court to deal with state actors and non-state actors equally. Actually, the last case that the court had is the case for the war crime of the destruction of cultural property in Timbuktu, Mali, and the accused person belongs to a group affiliated to Al-Qaeda. Now, lots have happened in the area of justice. But at the same time, the challenges have increased with the increase of action at the court. And we have to say that the future of the ICC cannot be taken for granted. It is a court that it is gradually more and more consolidated, but at the same time, the challenges increase. Now, the court has been criticized for real or for perceived flaws. And I have to say that creating the court was a very difficult endeavor, but the future is not going to be less difficult, in particular at a time when global concepts and multilateral institutions are being questioned. Now, what are these main challenges? And I'm really reducing here. I would say that we can divide the challenges maybe in two broad categories or titles. One is the importance of increasing the efficiency and effectiveness of the institution. The court has been criticized for very lengthy proceedings, and it has been indeed taken these criticisms very seriously. That has been actually my top priority as president of the court, to enhance the governance of the institution and to expedite proceedings. And we have taken a number of steps that are already giving a lot of visible results in our cases. We have, together with the judges, revised the proceedings, tried to identify best practices in the last 15 years. We have been producing even manuals chamber to try to reflect the agreements in order to indeed try to improve the proceedings at the court. We have to show that the court can deliver high-quality justice, because the court needs cooperation. And it is my conviction that performance and cooperation are interrelated. We need external cooperation. Sometimes our proceedings are slow because cooperation is not forthcoming, but at the same time, in order to enhance cooperation, we need to show that we can deliver. Now, that in the area which is under our control, which is to improve what we can do from the inside. Now, we have also the challenge, and this is far more difficult, to increase the legitimacy of the institution. And this is more difficult because, of course, legitimacy is based on reality, but it's also based on perceptions, and we need to be able to address both. Legitimacy may be affected by a perception that the selection of situations of cases at the court is not appropriate or not justified. Now, where to investigate, who to prosecute, were always meant to be the most difficult questions to be answered by the court, which is general and permanent. So where to go? This time, it's not the Security Council deciding to create a tribunal for a case or another. Here, it is the court that needs to decide where to investigate, who to prosecute. Now, the court, in the first 15 years of its activities, have opened investigations in 10 situations, which is basically a situation is a country, although in one country have 2 situations, but 10 situations. Out of these, all of them, except one, are investigations that have been opened in Africa. Only one, the latest one, is an investigation that has been opened in Georgia, in Europe. Now, of course, as you may know, this has created some friction with Africa, because, of course, the question is why a global court is focusing in one continent. Well, first of all, we have to go for the facts. Out of 10 situations, 7 of them have been opened by the court upon the request of states concerned or the Security Council. Of 7 situations, 5 have been requested by the states themselves. Uganda, Central African Republic, Democratic Republic of Congo, Mali, all these situations were requested by the states themselves. They asked the court, please open an investigations because we are not able to investigate and prosecute ourselves. 2 were requested by the Security Council of the United Nations in Libya and Darfur, Sudan. So this is already a first part of the answer. Some of these situations, of course, they are serious, they are very grave, they are within the jurisdiction of the court, and they were requested by the states themselves. Now, we also have to remember, because we also see situations in other parts of the world that would certainly deserve the attention of the court. And we see them every day in the television. We see, and one of the questions is always asked is, why is the court not doing something in Syria, for instance? Well, now we have to remember that the court is an organ created by a treaty. And that is a part of the strengths of the court, because the genesis of the institution is democratic. It's a treaty that has been adopted by all the states of the world in an important exercise of multilateral diplomacy. But that also is also at the origin of limitations. The court has now 124 state parties. So the court has a global mandate, but has not yet universal participation in the treaty. 124 states is a significant number, which was achieved rather quickly, but we have 70 more to go in order to be universal. Now, the court, the system of the court is not based on universal jurisdiction. This was not accepted in the treaty. So in order for the court to open an investigation, the crimes need to be committed in the territory of a state party or be committed by nationals of a state party. So you need territorial or active nationality nexus. That is absolutely essential for the court to have jurisdiction. The court cannot open an investigation outside these parameters unless the Security Council refers the matter to the court. The Security Council, in the exercise of its own competencies under the Charter, can refer a matter to the court, but the Security Council is a political actor, so it will refer or will not refer depending on its own interest and on political circumstances. So indeed, for the court to be able to open an investigation independently in all situations that would deserve the attention of the court, it is absolutely essential to enhance the universality of the treaty. So this is a huge challenge that it needs to be addressed by the international community. The court, of course, and the question is also, well, what can the court do for that? Well, the court has to do, and come back to efficiency and governance, the court needs to be able to show that it can perform. And actually, the court is working, and is working much better than at the early years, and it is attaining a very good speed in the current proceedings. And the governance also has improved. The court is also trying to engage as much as possible in a dialogue with all the stakeholders in the international community, with states, parties and non-parties, civil society, academia, legal professions, this type of event to try to explain what is the court about, what can the court do, what can the court cannot do. So the court is trying to do this, and it also is trying to reach out more to victims, to the local communities, to those affected by the crimes. And actually, we are having, in this sense, a great success. In the first cases we had hundreds of victims that wanted to participate in the proceedings. In the latest cases we have thousands. In the latest case, Onwen, more than 5,000 victims have already applied to participate in the proceedings through legal representatives, of course. This is a challenge to the conduct of proceedings, but it is also essential to reach out to those who are really affected by the work the court does far away in The Hague. But, and I finish with this is also a challenge for the international community. It is for the states to also express support for the institution, to be vocal when there is in their support when there is a crisis, and for all the global community to support the idea by cooperating with the court and expressing support for the concept. We saw last year that several states, 3 African states, announced their intention to withdraw from the Rome Statute. 2 of them came back, withdrew their withdrawals. 1 is still ongoing, the process of withdrawal, which is Burundi. But I have to say that was a crisis for the court, but that was also the occasion where the international community expressed a very vocal support for the court in a way that we had not seen for years. That was a moment where the international community realized that the court cannot be taken for granted, that the achievements in the area of justice of the last 25 years cannot be taken for granted, and that was a wake-up time for everybody. So this is what we all need to do, because of course, the concept of justice is something that we need to defend always. It's always work in progress. Thank you very much.
Thank you, Judge Fernandez. I will now call on our second speaker, Shahid Fatima, to talk on the Strasbourg Court and the UK. We'll take all questions at the end after all the 3 panelists have spoken. Thanks.
Ladies and gentlemen, good afternoon. It's a privilege and a pleasure to be here. There could hardly be a more important topic at the moment, and this could hardly be a more important gathering of lawyers, academics, and judges. I have to say it's slightly unnerving to share a table with President Fernandez, given that it's more customary for me to be standing in front of people like her, usually far lower down, looking up, beseechingly sometimes, than to be sharing a platform with her. So it's a great honor. I'm going to be talking to you today about the role of the Strasbourg Court and the UK. Now, there are a number of different levels in which this debate could be held. We could talk about the relationship on the international plane between the executive or the legislature or the courts. We could talk about the relationship on the domestic plane. We could talk about the relationship on a political level. What I'm going to do in the short time that I've got is to talk about the legal aspects of the relationship, and in particular on that balance between the international and the domestic planes, because I think that's the relationship that is most interesting for commentators and practitioners from other jurisdictions, because what it does is illustrate the role of an international institution in the 21st century vis-a-vis the domestic, and the domestic is where so much of human rights actually comes into play. And I'm going to begin by giving you a little bit of the background of the Human Rights Act 1998, a little bit of the political landscape, and then just making 2 modest points in terms of what I think should inform a consideration of the future of the relationship between the court and the UK. So, as you all know, the UK ratified the convention in 1951. It accepted the right of individual petition in 1966. So, for more than half a century, the UK has been bound by the Convention and the Court on the plane of international law. But the UK is and remains a dualist state, so these international law obligations do not, without more, have direct relevance or application as a matter of domestic law. Nevertheless, international law obligations were not ignored by the English courts, and certainly from the 1970s onwards, there was a discernible trend where one could see that international law was being referred to in legal argument and slowly being applied by judges, and the Convention was no exception to that. So one sees in the development of the English common law a joint endeavour, it sometimes appears, by the bench and the bar to use international law obligations, to use international human rights law obligations in the development of domestic law. So, for example, there developed a canon of construction called the presumption of compatibility. That presumption states that where there is an ambiguity or an obscurity in a statutory provision, the court should endeavour to construe it in a way which is most consistent with the UK's international law obligations. Now, by 1997, there was so much jurisprudence in this area, this ad hoc way of using international law as part of domestic law, that it filled a book, the excellent book by Murray Hunt, Using Human Rights in English Courts. So there is a history, a long and rich history of English judges and English common lawyers using the UK's international law obligations to inform the development of domestic English law. And that is a critical part of the history that is so often overlooked by politicians when they talk about the evils of the Human Rights Act. So moving on to then the Human Rights Act, it was enacted in 1998. It didn't suddenly introduce the Convention or the Court to English law, but it certainly formalised the status of it, and it was an important and unique development. It has three mechanisms. First of all, Section 2 says that there is a duty to take into account, that's the phrase, Strasbourg judgment. Section 3 is an interpretive obligation. It requires courts to interpret, insofar as is possible, English legislation compatibly with Convention rights. And thirdly, Section 6 makes it unlawful for a public authority to act incompatibly with the Convention. So what the Human Rights Act did was to indirectly incorporate into English law the Convention. And by doing that, it created a flood of litigation. It's become commonplace for the press to report on cases where a claimant controversially succeeds on relying on the Human Rights Act, and these cases often become political fodder. I want to just give you an example. Several years ago, Theresa May was part of a little political scandal which has fittingly been dubbed Catgate. She was Home Secretary at the time, and she gave a speech at the Conservative Party conference in October 2011. As part of her speech, she was calling for the Human Rights Act to be scrapped. And one of the points that she made was that Article 8, the right to respect for privacy and family life, was being used, in her words, to draw a coach and horses through our immigration system. Now, she also said something which I want to read out to you so I don't misquote it. And I should say that this is in the paper. I'm not sure you've all had access to it, but these references are in my paper. So she said this. She said, "We all know the stories about the Human Rights Act. The violent drug dealer who cannot be sent home because his daughter, for whom he pays no maintenance, lives here. The robber who cannot be removed because he has a girlfriend. The illegal immigrant who cannot be deported because, and I'm not making this up, he had a pet cat." Now, rather embarrassingly for her, she kind of was making it up, because that case that she refers to was actually about a Home Office policy on unmarried partners. The cat, it will not surprise you to know, was not the reason the individual was not deported. But Catgate is really important because it is a classic example of anti-Human Rights Act rhetoric. What it does is it presents the instrument as being exploited by the most undeserving members of society, the drug dealer, the illegal immigrant, the prisoner. And it makes people think that this is a system that's up for abuse, and often it does so by reference to inaccurate information. It also illustrates Miss May's antipathy towards the Human Rights Act, but she's not alone. This has been part of Conservative Party policy since 2010. The coalition, the Conservative Liberal Democrat coalition, set up a commission on the Bill of Rights. It unfortunately did not come to any unanimous conclusions. And a few years after Catgate in 2014, the Conservatives published a paper in which they set out their proposals for the British human rights regime. And they began by criticising the Strasbourg Court and the Human Rights Act. They said that these things, the court and the act, had undermined the credibility of human rights in the country. They said that the Strasbourg Court was guilty of mission creep, of using the living instrument principle to far expand the convention beyond the terms that the framers had intended. And they used 4 examples. They used prisoner voting rights, which I'll come on to. They used the fact that the court had upheld the right of prisoners to have artificial insemination on their partners and spouses. The fact that foreign individuals had managed to escape deportation, and also the ban on whole life sentences. So these were 4 areas that were identified of the court carrying out mission creep. The paper also criticised the Human Rights Act. It criticised sections 2 and sections 3, and I'll come on to that a little later. We then saw again in 2015 the Conservative Party manifesto alleging mission creep. In April 2016, Theresa May renewed her commitment to scrap the Human Rights Act. But then, of course, we have Brexit. So in April 2017, the Conservative Party manifesto says that there are no plans to replace or repeal the Human Rights Act whilst the process of leaving the EU is underway, that for now the UK will remain a party to the convention, and that this is something that will be considered once Brexit is complete. So that's where matters stand at the moment. And so one might think, well, we've got a bit of time. Brexit is taking all the attention, so us human rights lawyers and pro the Strasbourg Court individuals can rest easy for a while. But this is an important little breathing space, because this is the time where the quality of public debate can be informed. And we have witnessed only too recently what a poor quality of public debate in matters of international institutions can do. And that's why I chose this topic, because I think that this is the time for more informed commentary about the role of the Strasbourg Court, whilst there is this breathing space, this Brexit-induced breathing space. And of course, there are going to be political ramifications which flow from Brexit. The UK's position in the Council of Europe is undoubtedly going to be affected in some way by what happens there. And there are other political consequences. So, for example, the devolution arrangements in the UK will be affected if the UK decides to withdraw from the convention, especially in terms of the Good Friday Agreement. But I want to just conclude by looking at 2 points that I think are often forgotten, and to step away from the detail of the specific criticism of Strasbourg cases. The first point is that the Anti-Human Rights Act rhetoric often presents the Strasbourg Court judgments as being binding and enforceable on UK courts. And this is a simple error or misunderstanding of the nature of the relationship. As I explained at the beginning, Section 2 of the Human Rights Act does not give those judgments binding status, in contrast to the judgments of the EU courts. The English judges simply have to take the judgments into account, and they have been at pains to explain what this means. Very recently, in a 2010 Supreme Court judgment, 9 justices of the Supreme Court said in Manchester City Council against Pinnock, that these judgments are not binding on us. We should follow them if there is a clear and constant line of Strasbourg jurisprudence, but provided it isn't contrary to our fundamental procedural or substantive laws, and provided that there's no point of principle that the Strasbourg court can be said to have overlooked. And that was recited and referred to recently in another Supreme Court case. So this is something that the judges are saying. It's not, of course, what gets reported or the impression that's given of the status of these judgments, but it does need to be borne in mind. And of course, I note in parenthesis to that, that that's not to say that there aren't other nuances of that relationship. So, for example, if an English court does decide not to follow a Strasbourg judgment, the claimant is very likely to take his case off to the Strasbourg court. And the Strasbourg court may well say that the English judge has erred in his analysis. But that was the case even before the Human Rights Act. Claimants could do that since 1966. So the point is, the Human Rights Act is not the problem in terms of the role and the relationship with the UK. My second point, and it's a far more fundamental point, is that there is a real danger in this area of throwing the baby out with the bathwater. I could be said to be in that group of people that make their living from criticizing judgments and finding errors and defending errors. And it's very difficult to identify any court that could be said to be immune from the criticism that one or other or many of its judgments are flawed or analytically challengeable in some way. But when it comes to Strasbourg, what one often sees in the Anti-Human Rights Act rhetoric is a conflation. So the criticism of an individual case or the specific outcome is somehow expanded to being an attack on the legitimacy and credibility of the court itself. And that is where I think we are in danger of throwing the baby out with the bathwater, because what this rhetoric does is it ignores the vast contribution that the court has made. Whether one is in favour of the court or against it, I think it's unarguable that it has made that vast contribution to developing human rights jurisprudence. And it also focuses on a handful of often very politically controversial cases. So let me just elaborate that a little bit in the remaining time. The first point is that the UK has an outstanding rate of compliance with Strasbourg judgments. The prisoner voting cases that I'm about to talk about are very much in the extreme minority. It generally complies with and implements those judgments. It also has one of the lowest rates of defeat. There was a paper that was done by the Equality and Human Rights Commission in 2012, and they took a sample of cases, and amongst other Council of Europe countries, the UK's number of applications and number of decisions regarded as admissible and number of decisions that resulted in a violation were amongst the lowest. So I think there was a statistic of over an 11-year period between 1999 and 2010, there were 120,000 applications lodged against the UK. Of those, 390 were declared admissible, and a mere 215 resulted in a finding of a violation. So it's a very, very low rate of defeat. But what happens then is that the good work that the court does, the positive work, is forgotten. And amongst that, I've included in my handout a whole list of areas in which even in the last 17 years, the court has made a positive contribution. And they range from developing the investigative duty in Article 2 cases, the rights of transsexuals, the detention of foreign terror suspects, DNA profiling, balancing Article 8 and Article 10, the role of diplomatic assurances. These are cases that the UK was a defendant to, and they are restricted to post-2000. And so there's no doubt that the court has performed an incredibly valuable role in developing human rights jurisprudence. But what we get is the focus on the negative, the controversial, which brings me finally to prisoner voting. Now, for those of you that are not familiar with this debate, it starts with Section 3 of the Representation of the People Act, which is a ban on prisoners voting where they are serving a custodial sentence. And the UK lost this, first of all, in 2005 in a case called Hurst, which challenged that ban, said it was contrary to Article 3 of Protocol Number 1. And it succeeded, the challenge succeeded in the Grand Chamber by a majority of 12-5. The court controversially read into Article 3 of Protocol Number 1 the right to vote. That is a provision that deals with free elections. The court said that it wasn't an absolute right. There was a wide margin of appreciation, but that the English provision had exceeded that margin and therefore there had been a violation. That led in 2010 to another judgment, Greens and MT against the UK. And this time the court noted that the UK had not implemented what it had said in Hurst. And it basically gave the UK 6 months to put legislative proposals on the agenda, which the UK did not do. There were a number of developments between 2010 and 2017, but the bottom line is that the UK has not brought forward the legislative proposals in relation to the Representation of the People Act. But the 2 points that I would make in relation to that case law, which is often cited as a reason why we should withdraw from the convention, are these. First of all, one can say that the court got it wrong. Indeed, it's strongly arguable that the interpretation of Article 3 of Protocol Number 1 may well be wrong. But that doesn't undermine the legitimacy of the court. The court was performing its interpretive function. That is its treaty-given jurisdiction, and it was exercising it. The second thing is, it's often said, well, this somehow offends the principle of parliamentary sovereignty, but it doesn't. Parliament has a choice. It can either stay in the convention and comply with its international law obligations and produce legislation, or it can maintain its position in this rather odd position of staying in the ECHR and not complying, which has political and legal ramifications. Political because it's said to be setting a bad example. Legal because it's arguably contrary to the rule of law. As Lord Bingham said, the rule of law requires compliance by a state of its international law obligations and its national obligations. Or thirdly, it can decide to withdraw from the convention. So it's got 3 options. There is a choice for Parliament. Parliamentary sovereignty is very much in play. And so to say that the prisoner voting cases undermine the general legitimacy or credibility of the court, or generally undermine parliamentary sovereignty, is, I'm afraid, legally not tenable. Now, I would like to be able to say, well, this is where it should go next. We don't know where it will go next, and unfortunately, given some of the work I'm doing, I'm not able to speculate about where it might go next. What I would say in closing is this. With this Brexit-induced space, we perhaps now have the most important time in which we can really advance the debate on the Strasbourg court, because ultimately it's human rights that are going to transcend the ever-growing national and political boundaries that we seem to be seeing in Europe. Thank you.
I call on our last speaker, Mikael Madsen, to give his talk. Thanks.
Thank you very much. So my presentation will follow very much in the footsteps of the previous 2 ones, but being a law professor, I will have a tendency of broadening it a little bit more and make more general interpretations of it. The subject is a well-known one to scholars of international law. It's about what is observed as a growing pushback, even backlash, against international courts and organizations more generally in a number of places in the world. Interestingly, while this phenomenon has not yet entirely been explained, there's still already lots of explanations. So if you read the press blogs, you will see already that the growth of nationalist political movements, new forms of regionalism challenging universalism, even the election of Donald Trump and Brexit perhaps, are the causes of this. All these explanations at least have in common that they imply political change that do not sit very well with the idea of multilateralism that essentially underpins international courts. So what I'll try to do in this talk is to take a step back and assess the extent to which international courts are actually challenged. And I'll do that by bringing in some empirics from our work and also reflect a little bit what does it mean to challenge authority rather than just legitimacy. So just a brief note on where we start out. 5 years ago, we created I-Courts, and we did that against the thesis of the proliferation of international courts. I could observe there was a big difference from when I was studying law in the early 90s. There was 5 international courts. Suddenly, there were 25. We could also see that suddenly they would start doing a lot. There was now more than 40,000 judgments. When I was a law student, you can practically read them all. 90% have been delivered over the past 2 decades. And not just more and more active courts, they were also changing somehow, qualitatively. Most had now compulsory jurisdiction. Most allowed other agents and states to initiate litigation. And finally, and perhaps most controversially, and it links directly, some of them had, of course, a competence to review state compliance with international commitments, making them somehow into some kind of international constitutional courts. 5 years later, the picture some people are painting looks like this. A fire has broken out. And I think the revelation to many was the suspension of, and later basically closed down, of the SADC tribunal. But I would agree with the previous speaker that equally important was the Brighton Declaration in Europe, which presented a first ever systematic critique of the Strasbourg court, its judgments, and even its judges. And these were not isolated events. While the Brits were contemplating leaving Strasbourg, yet left Brussels instead, other countries had left the Inter-American Court of Human Rights. And other courts across the world were also facing serious critique and pushback. The big question for us, at least as academics, is, of course, when and where this kind of critique is actually threatening the authority of an international court. And to answer that question, I'm very sorry, you will have to go back to some theory. Because authority, when you think about international courts, more or less falls in 3 groups. First, the one we know the best, the classic legalistic one, concerned essentially with competence, delegated to international courts, and that's a legal question, it's a mandate that sets some boundaries. So the critique is typically, a critique of whether they've gone beyond the boundaries of that competence. It's a bit like the doctor in the picture. He can do something within the legal bounds of his certification and his scientific knowledge as a doctor. The doctor can be replaced with a lawyer, but it is visually challenged. A second stance of literature is normative approaches. We have many of those. And these generally measure authority against some ideal characteristics of an institution, and they presume, generally, that compliance pull of law derived from the sense that that institution applying the law is doing it somehow right and in a legitimate way. That means also, in this theory, that judgments and courts that meet these normative thresholds will be legitimate and generate authority. A third variant, which I lean towards, comes from sociology, and more precisely Max Weber, which basically says that authority of an institution can have multiple reasons: tradition, charisma, legal rationality. It also means, conversely, more importantly, there can also be all kinds of reasons why you reject authority. And, it can be charisma, legal rationality, and so on. If that is true, that follows from that it is not just to live up to certain normative criteria that's necessary for having authority. You can, in a way, be challenged in your authority for simply having authority, as you know, as a law professor, you will be occasionally. So, what this says, if you combine these 3 definitions, it is that it is not entirely in the hands of international courts to control their authority. They can do some things, which relates to 2 first variations of this, but as I've argued elsewhere with Karen Alter and Larry Helfer, international courts can actually do everything the normative theories prescribe for them and still not have authority. That raises then a question, who is it then that challenged the authority of international courts? And the best known example, of course, that we all know is the SADC Tribunal, which was suspended after it ruled against the interest of one of its major stakeholders when it ruled on land rights issues in Zimbabwe. The process of dismantling this court, interesting enough, played out at a very high political level. And it concerned what Rand Herschel has called megapolitics. And that is, I quote, core political controversies that define and often divide whole polities. And we look into the case of the SADC Tribunal, you will realize that it was the extraordinary charismatic power of President Mugabe that actually allowed for creating the coalition. The basic lesson learned from the SADC Tribunal is an important one, that is that powerful political context matters and it can result in what is rightfully called backlash. But the SADC case is in a way too easy because it was a very young court that has hardly established itself and it hardly got off the ground before it was closed down. A much older example is the Central American Court of Justice, set up in 1907 and operational until 1918 in its first incarnation. This court was dismantled when they ruled against Nicaragua about a plan they had to set up a US naval base in the Gulf of Fonseca. This led to the close down of the court, and then an earthquake took care of the rest. What you can see in the Central American case, it is that it was a question about megapolitics again, a US naval base that led to the court being closed down. If we fast forward in time, we take the second Central American court set up in 1994, now in Managua. This court also had a major challenge at the point, because in its jurisdiction, by copying the original Cartago court, it has jurisdiction to oversee the separation of powers in the member states. And at a certain point, a coup d'etat was in the making in Nicaragua, and that case, known as the Bolaños case, President Bolaños from Nicaragua, was taken to the Central American Court, and it ruled in favor of the president. There was a violation of separation of powers. Again, a mega political issue. Interesting enough, when political alliances changed, they stripped the court then of its competence to rule on these matters. But so although the reform was prepared, it was never adopted. And this is something that you will see more places. So the best explanation is that even though you'll have the pushback, you might even have a reform, it might well not be adopted. And that is due to something that's very different, that is that political time and institutional judicial time are two very different phenomena. The politicians come and go, institutions tend to remain a little longer. A third example is the East African Court of Justice, which in the aftermath of a set of rulings where it sort of expanded its jurisdiction in terms of rule of law, was met with a pushback from Kenya. The first suggestion by Kenya was actually to eliminate the court, and if that would not work, they will get rid of the Kenyan judges. In practice, this plan never worked out. Instead, what you got was an introduction of an appeals chamber, where you put in state-friendly judges to rule in a way that could revisit the jurisprudence. So here you have a sort of backlash, not elimination, but certainly a change of trajectory. Fourth example is the ECOWAS court, you get it here. That court also faced serious pushback, this time by Gambia, and they also prepared a big reform because it started ruling on human rights issues. But Gambia was not very legitimate among the other member states and never managed to create a coalition. And therefore, what really happened was just a strong signal with impact no one has yet assessed. Another example, of course, the ICC, but we have already heard about that. It is also permanently under strong critique, including by academics. And then a sixth one is, of course, the European Court of Human Rights. The European Court of Human Rights is unique in the sense that if you look at it, not just from the point of view of Britain, but from the point of view of Europe in general, that it is generally considered and debated both in the legal fields, but certainly also in the public media and in the public at large, and that you will find segments in all these groups that are very critical of the court. If you take this country, we have had posters like this, Who Decides in Denmark, and the Brits, they look like this. This media attention is important because is on one hand side, it's perfectly true what's just said, that is generated by the media's obsession with these rulings, but at the other hand side, it is also very much the result of the way politicians react towards courts. They generate a somewhat vicious circle in this regard. And notably in Europe, it's been Russia and the United Kingdom. But you should be aware, and it's one of the lessons learned from Africa, that one country being a bit loud is not going to change it. It requires more. And where you got that one more thing in Europe, actually, with the Brighton Declaration, which was adopted by all 47 member states, and as said, it was an unprecedented critique of the court and its way it functions and even its agency. The message of Brighton is a very simple one. That is, more power to domestic institutions, judicial and political, in other words, more subsidiarity in the system. Interesting enough, Brighton and the two resulting protocols are not in effect yet. And actually, honestly, it's quite questionable whether Protocol 16 ever will go into effect. I would doubt that. So you have a situation where you have a very strong signal, but actually the legal reform has not yet been implemented. This, of course, gefundenes for academics, so we start studying what happens when you have such a strong signal towards an international court. Does it change, or does it just sort of ignore it? Well, so what we did is we took all the case law before and after Brighton and saw whether the court was actually giving more deference, more subsidiarity via its doctrine of the margin of appreciation. The grey column shows the growth in margin over the past years. The Brighton is in the middle. Actually, interesting enough, the growth in margin appreciation in Strasbourg started prior to Brighton, started after the Interlaken document, which itself sought to introduce a margin. I mean, you can find this paper on SSIN. The main point I want to make here is just that this strong signal, even though it's not legal yet, has been enough for seeing a transformation in Strasbourg, which is particularly visible, if you go a little bit deeper into it, with regard to two controversial areas of law, that is Article 8 on privacy and Article 35 on access to the court. So, how can we explain all this? I've given you 6 different examples. Well, first, I think it's necessary to differentiate a little bit between all these situations. Actually, what you can see if you do the global view of courts, there's a distinction between mere pushback and actual backlash. That is, you can distinguish between the merely rhetorical actions against courts and then the actual institutional reforms seeking to weaken or even demolish courts. And within each of these two categories, actually, you can make a little continuum between from weak to strong. Then it looks like this. What becomes apparent is that over 100 years, we only have 2 instances of demolishing an international court. The one is the SADC, and the other is the Central American Court of Justice. The Central American one was actually not really axed, it was left to expire under a sunset clause. The East African example, I think, is very telling, because it's where you get actually a reform that somehow weakens the court. In the case of the European Court of Human Rights, as well as the Central American Court, number 2, what you have are very strong signals, even prepared reforms, that are to be implemented one day. So the most striking observation, if you want, is that strong signals is the most used reaction within the sample of courts studied here. But if we expanded the sample, included, for instance, the Inter-American Court of Human Rights, the European Court of Justice, and the Andean Tribunal, it would not change much. From this follows something that's interesting. That is that international courts are actually relatively robust, and they seemingly only go under when they become entangled in mega politics. It also follows from this analysis there's a great difference between a critique which is mainly in the interest of a single state and a critique that can mobilize all member states. Backlash, in a way, requires the mobilization of more, if not all, member states, and that's where you have the East African example. But as you know from East Africa, to mobilize everyone, you might have to compromise. That's the East African example. But actually, Brighton, if you ever read the leaked version from the Foreign Office and compare it to the final Brighton, you will see it is a very softened document. So what does this imply? Does this imply that the current obsession with backlash is exaggerated? Well, if understood as an action that seeks to close down an international court or substantially change its legal trajectory, then the answer is yes. But if we consider authority challenges more broadly, include softer forms, for example, pushback in terms of strong political signals, we should be a lot more careful. What we can observe with the outlined examples is an increase, actually, in authority challenges in this softer category. Some of these reactions are, put a bit rudely, temper tantrums of governments. They come and go. And if you look into the history of international courts, you will find these occurring again and again. There's nothing surprising in governments being a bit unhappy with adversarial rulings, and you'll find instances of non-compliance. But what has changed, though, in the history of this is the pathways of critique. When you look at the European example, but also the East African example, you will realize that the spread of negative discourse has been accelerated greatly in recent years. And this speed of politics, fueled by the media, is very difficult, if not impossible, to keep up with for international courts. This creates this new politicization, a new form of fragility in the whole system. Some would argue that is only natural. If you have that much power, you need to be repoliticized. There has to be checks and balances and feedback loops. But what we are observing are hardly healthy feedback loops. It is something else. It is probably an element of a renewed anarchy, to speak like an IR scholar. That is that in each and every case, we find powerful states dictating, regional hegemons or global powers. It's the United Kingdom, it's Kenya in East Africa, and it's Zimbabwe in the southern cone of Africa. And this, if this is the general pattern, that is ultimately a real threat to multilateralism. Thank you very much.
We have about 25 minutes to take questions, and hopefully our panelists will respond. Because of time constraints, I'm going to just take 4 questions, and we'll take all those 4 questions at once. And our 3 panelists will have a choice of which ones they want to respond to. So please put your hand up. This one here, this side.
Does it work? Hi, thank you very much. I have a strategy question to Shahid Fatima. So supposing that the final goal is not to shut Theresa May up, but actually to maybe stop the populist views, to change the perception of the public. Assuming that the judges in the UK can anyway interpret the British law based on the Strasbourg court's interpretation, based on the assumption they could do it before, and based on the assumption that even with the law, they're required to interpret but can't go against the British law, in terms of strategy, wouldn't it be better to do away with the Human Rights Act? Or at least with the requirement to interpret the British law in light of the judgment of the Strasbourg court, and the judges will still be able to do the same, only Theresa May would not be able to make populist claims against the Human Rights Act. The judges will still be doing the same thing. Thank you.
Yes. Hello, thank you. This is to President Fernandez. I know that one of the striking features of the ICC is its innovative approach, as you were saying, to reparations. And I was wondering whether you could share with us some of the challenges, maybe first lessons learned about the early experiences with reparations for victims, which I take is a very daunting task. Thank you.
Thank you very much. My question goes to pushback or backlash relating to international courts. I come at it from the perspective of the European Convention on Human Rights and the UK perspective. The point I'd like to make, although I don't think I should push it too strongly, is it's not just politicians who've criticised the court in Strasbourg. there have been some high-profile examples of senior members of the UK judiciary criticising Strasbourg. That's dangerous because it gives the political rhetoric a level of kind of legal credibility. But I also think it's important to the kind of feedback loop that Professor Madsen was referring to at the end there. The question I'd like to put, therefore, is whether any of the panel are familiar with such feedback loop being occurring in respect of other jurisdictions across Europe, not just the UK. That is to say, judicial criticism of Strasbourg at the national level in other jurisdictions rather than the UK, and what impact or effect that may have. Thank you very much.
Take one more question, Chris.
I think we heard in that last speech that some of the backlash may come from governments themselves that set up the courts in the first place and then don't like what they do and try and undo what they've done. But in the case of other courts, the International Criminal Court, European Court of Human Rights and others, I would just raise the question as to where responsibility lies for the ability for this kind of backlash to occur. My experience of countries I know, and I imagine it's the same elsewhere, is that where the Supreme Court of a country gives a decision, even if it's controversial, the public tends to accept it. Sometimes even governments like Supreme Courts to give decisions contrary to the government, because then the government doesn't have to take political responsibility for what has happened. And the government will say to the people, don't blame us, we vigorously oppose this in court, but it's the court that has imposed this solution on us. And yet there's no backlash against the court then. The public seems to say, well, okay, that's what our Supreme Court has decided, and that's it. Even sometimes courts domestically give very controversial decisions, and there may be some public outrage at the decision the court's given, but no one says, let's abolish our courts or let's sack all our judges. So if there are these kind of reactions to international courts, it seems to be because they are international, they're not domestic, and therefore the reason seems to be a failure to sell to the populations of the countries concerned that internationalism is a good thing, or that an international court is still our court. And if the population, if the general public has not been persuaded of this, I raise the question, whose fault is it that the public has not been persuaded of this? Can we blame governments for that fact? Or is it lawyers more generally? Or is it somebody else more generally? I think that is a major issue in the world today, but I would invite comment on that.
Thank you. I think I'm going to call on our panelists to respond, and we'll see how we are doing for time. And we may or may not take a further round of questions. Thanks. Feel free to respond.
Okay. I'll go first to the first question to me, which I think was, why don't we do away with the Human Rights Act because it will shut Theresa May up? I don't have a... Sorry, that's just a paraphrasing of the question for brevity rather than to undermine its significance. I don't have a problem with scrapping the Human Rights Act if you can come up with something appropriate to replace it. But it's curious how few concrete proposals the Tory party has put forward in relation to its British Bill of Rights. And this is one of the real questions. Where is this document so we can all actually assess it? And the second point I would make is I think it depends in terms of scrapping of the Human Rights Act what it is that you want to try to protect. If you want to protect individual rights in the UK, then a British Bill of Rights may well be perfectly adequate. If you want to actually try and secure a pan-European system where there are countries that have a public commitment to international human rights, then that's not good enough. And I would argue that we shouldn't lose the latter and just concentrate on the former, that is a retrograde step for international human rights lawyers in general.
Following on the questions about the critique in other places than just the UK that I highlighted, I think the point I was trying to make is actually this critique that you will find in one place is generalizable, and it spreads extremely fast. I could give you empirical examples of critique in this country, in place like Finland now, that will be unthinkable 10 years ago. We actually have occasions of the Finnish president of the Supreme Court in practically denouncing the European Court of Human Rights. We have examples from this country, also former presidents being very, very critical. And I could go on and on. You will find this. The point is that what once was sort of an exotic phenomenon in the common law is now becoming a civil law matter as well. It is a generalizable, but the interesting thing is it is generalized or diffused without context. So when you launch the same critique in this country, it is without the background of that critique. It is a critique for the sake of critique. It's the authority challenge of the authority per se. So, and I think that is a new phenomenon, and it links to the other question about, so what is different about international courts in this sense? Well, I think the main difference is, of course, that their authority, very differently from national courts, has to be constantly revitalized, has to be remade anew. And you don't have that problem with national courts. They can withstand fairly robust critique because they're baked into the constitution and the culture after all. International courts you do away with. Therefore, you have an authority game that you don't find at a national level. And that, of course, can have all kinds of reasons, but obviously if I'm right in the way I assess authority as mainly in the hands of the constituencies rather than just by doing the legitimate thing, well, then it is a question about convincing those authorities about what is next thing. I would like to echo what was said by Fatima about this moment we're in right now. You know, many have said that the Brexit created a wake-up call in Europe, but it's certainly a wake-up call that can easily be overdone by a siesta very soon, because not that much has happened yet. But there are attempts, though, at revitalizing that popular support of Strasbourg Court for those very reasons.
Yes. I did the wrong thing. Yes. I would like to address the question on reparations, which indeed, as I said, is an important feature of the International Criminal Court, is that victims can indeed seek reparations for the harm they have suffered. And we are now starting to test the system at the ICC, because reparations is different for the International Criminal Court, different from the experience of a human rights court. Reparations cannot be addressed to the state, but indeed it is for the convicted person to pay reparations to the victims. So that means that is one of the first problems that we have, is that we need to wait for the end of the trial in order for victims to start requesting reparations, because you need first a conviction. That is already a problem, because that may take a long time between the start of the proceedings until the point where the victim can indeed seek reparation, and that we need to address to see. Of course, we need to wait for the conviction, but we need to find ways of accelerating the process of reparation. So that is a matter of process. Then we have some legal issues, and we see different questions that are being addressed in different manners by chambers at the court, which is still testing certain concepts. Who is a victim? How you assess the harm of individual victims. That, in practice, is proving to be extremely difficult. And of course, when we have more and more victims coming to seek reparation, when you have thousands of victims, then the issue of whether individual reparations are indeed the most appropriate solution is a question. And of course, the court can also explore collective reparations, that is to develop projects for the victims. So both things are being tested. We have now, the court has issued the first order for reparations in one of the first cases, Katanga, where it has afforded individual reparations symbolic. So basically, they have resigned. They could not do really an assessment of each individual harm, and they have given a symbolic individual reparation to everybody, which is basically the same to each victim. And in parallel, they are developing now projects for the victims in order to expedite. And the individual reparations are now being paid. Also, of course, the second problem is the issue of resources. to pay reparations, if it is a financial compensation, you need resources, and that is a constant struggle. We have a trust fund for victims. The trust fund needs resources. One little to address the issue of international criminal courts, and I would like to add on the difficulties for an international court to address, to have a direct dialogue with the public. Indeed, an international criminal court is in a very different position from a national court, which is, as it has been said, embedded, already established in one system. Although we do see a lot of examples where also national courts suffer when their decisions are not liked by the political power. But an international criminal court has the extra problem that is not necessarily known by the publics of the world, and that because it is international, is really detached by definition from any system. That's why, and I said it also that very briefly, the court is doing huge efforts to do to reach out to the general public of the world, but in particular to the public of the situations that are under investigation, in order to have more of a direct rapport with the local communities. Because one of the great challenges and great problems of conducting proceedings in The Hague, far detached from the victims, is that you end up having a court that doesn't belong to anybody. And also we are trying to conduct proceedings in situ, but that also raises a lot of challenges in terms of security, cost, etc. But it is a problem indeed. Thank you.
We're not going to take any further questions. We promise to bring this session to an end on time because many of you have flights to catch. So I'm very sorry. It just remains to me to thank our three panelists for very profound insights into the challenges facing international courts in the 21st century, and to call on our host.
And I would like also to thank all of you for coming. I would like to thank the co-presidents, Graine and Ran, Maria, not the least, for doing the real work here. And I think I'll just close by saying, as we have heard perfectly well here, that the power of courts and public law is not just state business. That is democratic business in the most basic sense of the word. Thank you for coming.
Well, I will just take one final minute of your precious time. I know we are all sitting on our suitcases, so to speak, and we have to rush to the airport, not least the president of the ICC. So on behalf of ICONAS and my co-president, I want to, again, deeply thank the organizers for hosting us so beautifully and impeccably over the last 3 days. It's been really fantastic. Thank all the speakers, the chairs, the plenary panel speeches. It's been fantastic. But mostly I want to thank all of you for being such supportive of this somewhat entrepreneurial enterprise we call ICONAS, the International Society of Public Laws. Really, thank you all. The second thing I want to say is to announce that the 2018 annual meeting of ICONAS will be held in Hong Kong. It was, yes. And will be hosted by the University of Hong Kong Faculty of Law. The dates, mark your calendars, are June 25th to 27th, 2018. And you are well advised to book your flights and hotel rooms in advance. More details to follow, but we thank, of course, the University of Copenhagen, but in advance, the University of Hong Kong for willing to take on this somewhat daunting but very satisfying challenge. And finally, obviously, we've done some things well, as expressed by, or as manifested by the, how inclusionary the society is, or at least aspires to be. It's exponential growth. We started with 300 and some, and now we reached 1,000 within, 3-4 years. Certainly, there is some room for growth, not numerically speaking, but in terms of all sorts of things that we might do better. So we would like to hear from you. Of course, good things and congratulations are always welcome, but we would like to hear from you if you have any suggestions and some constructive criticism on how to do things better. By all means, email us, not over the weekend. Let us all rest for the next 48 or 72 hours, and then come Monday, please let us know what you think. Thank you all, and we look forward to seeing you in 2018 in Hong Kong.